one case on the calendar this morning, Antonio Melton versus the State of Florida. We've allotted 15 minutes per side. We'll hear from counsel for the appellant.
Thank you. I would like to reserve 5 minutes for rebuttal, please.
Okay. I assume somebody's explained to you how our clock works.
Yes, sir.
Okay.
This is a case that involved a post-conviction evidentiary hearing. Mr. Melton had been convicted of the murder of Mr. Ricky Saylor. That was what often in the briefs was referred to as the taxi cab murder. One of the reasons that it's relevant and that it needed to be distinguished was there was also a murder that involved Mr. Carter that was a pawn shop murder. At the evidentiary hearing, Mr. Melton produced 6 witnesses to state his innocence as espoused by the co-perpetrator. He ended up not being charged. The young man's name was Bendy Leon Lewis. Ben Lewis is what I think he was referred to as most often. These witnesses were incarcerated with Mr. Lewis.
Tell me about is it Houston or Houston?
Mr. Houston.
Tell me, he didn't change his testimony in any way. Didn't he also identify your client as the shooter?
He did, and he testified to such.
Well, why wouldn't that evidence by itself be sufficient to support the trial judge's conclusion that even if all this other stuff were true, it wouldn't be likely to produce a different result on retrial?
The witnesses that were produced stated that Mr. Lewis told them that he and Tony Houston were the ones that were present, not Mr. Melton, indirectly impeaching Mr. Houston's testimony. Mr. Lewis actually told, I believe it was 4 of the 6 witnesses, that he in fact was the trigger man.
All of whom were inmates? Yes, just as all of whom, I'm sure, had lengthy felony records.
That's correct. Just as Mr. Houston and Mr. Lewis as well. The interesting fact is that they stood nothing to gain, whereas Mr. Houston pled to a second-degree murder charge and received 10 years.
How do we know they had nothing to gain? I mean, don't these people usually come forward in the hope that they're going to get some reduction in their sentence as a result?
As to when they testify for the state, yes. As to when they testify for the defense, post-conviction counsel had nothing to offer these witnesses whatsoever, and there was never any impeachment on cross-examination that any of the 6 witnesses that came forward stood to gain anything whatsoever.
How long did it take them to come forward?
It was approximately, by the time you got to the evidentiary hearing, it was about 11 years because it tracked.
After they had supposedly been told?
Yes. However, Mr. Summerlin, or a.k.a. Summerlin, now we know him as Sumler, had actually told the detective O'Neill back in 1991 as to what Mr. Lewis had said. Unfortunately, that was never relayed to Mr. Terrell, that was Mr. Melton's trial counsel. Although there was a deposition, there was some controversy as to whether or not Detective O'Neill's notes were actually in fact received by Mr. Terrell. That was a point of contention at the post-conviction hearing.
Isn't that a fact question? I mean,
I'm sorry, I couldn't hear the
there's
first part.
competent, substantial evidence to support the judge's determination regarding that issue. It doesn't matter whether it was in contention, does it?
Well, I think it does, because there's essentially 3 bases which this court can grant relief. That would be that the Brady claim that was pled is a valid claim, or that the newly discovered evidence claim that was pled is a valid claim, or that Mr. Terrell was ineffective for not in fact following up on, if he had received those notes, for not in fact following up on the notes. Speaking to Mr. Sumler, which when post-conviction counsel spoke to Mr. Sumler, that kind of produced the domino effect of all these other witnesses being obtained and finding out exactly who was speaking, Mr. Lewis was speaking to within the Pensacola County Jail. Mr. Sumler actually testified that everybody in his pod knew what Mr. Lewis was doing, and that there was 24 inmates to a pod. So with a reasonable degree of investigation, if it had been followed up on, these witnesses would have been found. So either it was withheld and it's Brady, or Mr. Terrell couldn't have discovered it through due diligence and his newly discovered evidence, or he knew about it and didn't follow up and conduct a reasonable investigation. So I guess it's important in the sense of what basis of relief is granted if this court in fact grants relief.
Even if one of those is true, you still had to convince the trial judge that the result would likely have been different had that information been known. I mean, you still got Mr. Houston to deal with, and obviously you didn't convince the trial judge that even if these people had come forward, it would have been likely to change the outcome.
Well, I think when one looks at the trial judge's order, I would ask this court to essentially disregard the credibility finding, and this is why. It doesn't go into any specifics as to any witness. It's a categorical rejection of the testimony because, in fact, they were convicted felons, and it took them a long time to come forward later. If that's the case, we would never be able to advance any newly discovered evidence claims, any of the recantation testimony that takes place. And so a categorical rejection in that sense is not the individualized credibility determination that should be given deference, such as the way somebody relays their testimony and the things that only a trial court judge can see that's viewing the actual testimony. The credibility finding in this case was just a categorical rejection of that kind of testimony.
So essentially you're asking us to retry this on appeal.
Not entirely. Just as to the validity of these witnesses and their statements, the fact is that when you have 6 witnesses, we're not just talking about 1 or 2, we're talking about 6 witnesses coming forward, 4 of them saying Mr. Lewis said he was the actual shooter, that there is a strong likelihood that it would produce a different result on the retrial if these had in fact been presented initially. Presumably we wouldn't be here today. As to Mr. Houston's testimony, there was the issue of whether or not the actual deal that he received was revealed or not. He had signed a waiver of speedy trial on April 28, 1991 that was apparently part performance on a plea agreement that was dated the same day, April 28, 1991. He didn't formally enter into that plea until October 9, 1991, after Mr. Melton's trial had concluded, and that's when he received the benefit for his testimony, which was a plea to second-degree murder and 10 years in the Department of Corrections. Mr. Lewis didn't receive his benefit until after the capital case, and he as well was sentenced to 10 years. Both those gentlemen have since got out, and I believe Mr. Houston actually went back on a violation of probation. The interesting thing in this as well is the trial court states that these statements wouldn't have been admissible. Our contention is they would have been admissible. They would have been admissible as a statement against interest. Mr. Lewis, to this day, could still be prosecuted for murder. There is no statute of limitations on that. Him saying that he was the actual trigger man is a statement against his interest in one of the most extensive manners that you can have as far as him being able to be prosecuted for murder or for perjury. The other thing is that it could fall within the exception of the statement of a co-conspirator in furtherance of the conspiracy, because he was furthering that conspiracy to avoid conviction and detection, which he never got prosecuted for that case, so apparently it worked, as well as furtherance of a perjury conspiracy. The reason it was originally pled as a Brady claim is when you look at the notes and the testimony of Detective O'Neill, those notes clearly indicate that there was a conversation with Mr. Sumler, and the notes also revealed where he had written in that Mr. Melton was involved, scratched it out and put partner, which actually corroborates what Mr. Sumler said, when Mr. Sumler said that he had told the detective that, in fact, Mr. Lewis had told him he was there, and he was there with Tony Houston, and that he was, in fact, Mr. Sumler, in fact, thought that Detective O'Neill was going to present to the court the information that he was relaying him on behalf of Mr. Melton, which explains part of the reason for him not coming forward. I'll reserve the rest of my time for rebuttal. Thank you.
Ms. Millsaps?
May it please the Court, Charmaine Millsaps representing the state. Hopping right to this, what he wants to present, why this would never change the result in a different outcome in a retrial, is he wants to present evidence as to who's the shooter. Melton was convicted of felony murder. In a felony murder conviction, it does not matter who the shooter is. This conviction remains valid regardless of who the actual triggerman was in this case. These 6 inmates, each with multiple prior convictions, we're talking 20 and 24 and numerous convictions, many years later, without any reasonable explanation for their delay in coming forward, testified that a defense witness told them statements that were inconsistent with the defense witness's testimony. Lewis was a defense witness. He was not a prosecution witness. Houston was the prosecution witness. Moreover, Lewis himself has never recanted his testimony. Neither Houston nor Lewis were called at this evidentiary hearing. Neither recanted their trial testimony. For him to be able to, what he wants to do is put, I guess, a retrial where we would argue about who the shooter, although that's not relevant, but he wants to put up a defense witness, Lewis, and then call a parade, literally 6 witnesses, to impeach them on something that's not even relevant in a retrial.
To impeach his own witness.
To impeach his own witness about something, about who was the shooter, and that's not relevant. And you're not allowed to call the parade of witnesses to impeach your own witness. So this would not be admissible on a retrial. It's not admissible under a penal interest, a statement against penal interest. Remember, what's really what they even have a possibility of getting admitted at the new trial would be that Melton's not there, because that's the only thing that's relevant. The 2 inmates that testified that Melton wasn't there. But that's not a statement against Lewis's penal interest. A statement against penal interest must be personal to you. It must be a statement against your interest. Where Melton was is not a statement against Lewis's interest. Secondly, you must establish unavailability. There was nothing offered at the evidentiary hearing that Lewis is unavailable. And then last, you have to have corroborating evidence showing its trustworthiness. Getting right to the trial court's finding, he found these inmates to be incredible. That's a finding of untrustworthiness. And no, you should not look behind it. And I would point out to the court what Justice O'Connor has said. Affidavits like this are not uncommon, especially in capital cases, and they should be treated with a fair degree of skepticism. And they said they are suspect when they are produced at the 11th hour with no reasonable explanation for nearly a decade-long delay in the case she was dealing with. This is over a decade-long delay. And these inmates have no reasonable explanation. Most of them had no explanation. And the few that did have an explanation, they were partial, incomplete. So there's no explanation here. And there's nothing wrong with the trial court taking into consideration that he's dealing with inmates who delayed over a decade before they came forward with their testimony. As for Brady, this was disclosed as the trial court found. And let me tell you what this is. Sumler made a statement. Allegedly, what he heard was Lewis told him that his partner shot. Not that Lewis himself shot. He says that at the evidentiary hearing. Sumler's testimony is itself inconsistent. What they had pretrial and what the state had and what the state disclosed was that Lewis was saying that Melton or his partner shot the taxi cab driver. That's what they had, and that was disclosed. Trial court factual finding is absolutely supported by this record. It's not contradicted at all by this record. That's what the state had. The state has an obligation only to disclose what it has. It doesn't have an obligation to investigate further. Brady only requires that they disclose what they had. We disclosed what we had. We did not have Sumler's statement now that he changed his story and now is saying that Lewis told him that Lewis was the shooter. But that's not what we had. And we disclosed what we had. And moreover, there's no prejudice. Brady has a prejudice prong. That was the entire point of putting Lewis on the stand. Counsel explained his trial strategy at the evidentiary hearing. There were two counsel here, Judge Terrell, and he had co-counsel. And he explained at the evidentiary hearing his whole strategy was to put Lewis up on the stand, impeach him with the fact that he had lied under oath twice, both in his depo and the sworn statement to the state attorney, and also to highlight that Lewis was getting a deal in a capital case for doing this. He was impeached. He got an open admission in front of the jury that Lewis had lied under oath. And he also got an admission from Lewis that he would receive favorable treatment, that it was his expectation, his hope to receive favorable treatment in the related capital case. Moreover, this whole parade would undermine his theory of defense. His theory of defense is to impeach Lewis and to have it spill back on Houston. That's what he was trying to do at trial. And you cannot take, what he's really saying is that people like this can't be believed. You just can't believe this. There's reasonable doubt in this case, is what his theory was. And the reasonable doubt is that people like this cannot be believed. And then you put up 6 inmates and expect the jury to believe them. You have to make a consistent defense. And so it was better to do it just the way he did it. Moreover, these inmates, as I said before, were not available to him. Nobody knew. These inmates have only come forward now. So there is no deficient performance, and just as the trial court found, this is not admissible, and it is not likely to produce an acquittal at retrial because it really goes to something that's irrelevant. This was a conviction for felony murder. Who the shooter is may matter later in the capital case up in the Florida Supreme Court, but it does not matter here. Thank you.
This evidence is not merely cumulative impeachment. It's exculpatory. It's exculpatory in that the witnesses that were brought forward said that not only did Lewis say he was the trigger man, he in fact said that Mr. Melton was not even there.
How would you get it in a retrial? What would be the means you would use to get this evidence in a retrial?
You can call these witnesses and you can get it in as a statement against penal interest or a statement of co-conspirator in furtherance of the conspiracy to show that it was Houston and Lewis, consistent with the statements that were given by these witnesses as to what Mr. Lewis had actually told them.
Regardless of whether Mr. Lewis testifies?
Yes. Additionally, there was... of
course, the statement that Mr. Melton was not even there would not be a statement against Mr. Lewis's penal interest.
Not that standing alone is not against his penal interest. However, it should have been disclosed as exculpatory because the state's casting a...
How can you disclose something you don't know? You didn't present any evidence. The state knew that witnesses had were willing to testify at the time of trial that Mr. Melton wasn't even there.
Well, it falls within the Brady or the newly discovered evidence aspect of it, because had they disclosed the contents of the conversation with Sumler and that it was actually Sumler, a reasonable investigation would have produced that. And I believe I had cited in the brief to Rogers and Ochacone and Way
let's
for that proposition.
let's assume that you're right about Lewis's alleged statements to these people, that he was the actual shooter, being a statement against penal interest, which comes in on a retrial. Even if that's true, I still don't see how you get the Melton was not even there evidence in, because that's not a statement against penal interest. That's purely and simply hearsay.
Well,
and without that coming in, it seems like who was the shooter, as Ms. Millsap suggests, has no bearing on a felony murder conviction.
Well, that would additionally come in as to impeaching Lewis and impeaching Houston.
But Lewis isn't going to testify unless you call him in a retrial. The state doesn't use him in a retrial.
I guess they could or they could not. I don't know how they would retry their case. However, whenever you bring in the evidence regarding Lewis, you can still call Lewis and you can still impeach Lewis.
You can impeach your own witness.
Absolutely.
Okay.
As to Detective O'Neill, the other violation that was important is that Mr. Terrell was prevented from impeaching Detective O'Neill, and Detective O'Neill never really came forward with the evidence as to how many contacts Mr. Jenkins, Lewis's attorney, had in setting up this deal and setting up this cooperation. Whenever you look at the report, it appears that the detective approached Mr. Lewis's attorney, Mr. Jenkins. Post-conviction counsel presented the billing records of Mr. Jenkins that showed that no less than 17 times had Mr. Jenkins contacted the state on behalf of Mr. Lewis to set up this deal, which would have furthered Mr. Terrell's stated strategy of that Mr. Lewis came forward. He was maneuvering around trying to set up a deal and get himself, not in this case he ended up not getting charged, but at least obtaining a benefit for himself. As to undermining the theory of defense, it doesn't undermine the theory of defense whatsoever. It just goes to show that someone that's an accomplice is not to be trusted, particularly whenever they're doing the kind of or perpetrating the kind of actions that Mr. Lewis was, where he's going around asking people for advice as to what he should do, coupled with all these contacts with the state attorney's office. I see my time's through. Thank you very much.
Thank you both. That concludes the calendar for today. We'll be in recess.